Hello and welcome to the conversation here on News Central Television. This is the program where we bring you all the latest political updates and happenings on the continent of Africa. I'm Gbenga Aborowa.
And I am Rita Omodia. Happy New Month to all our viewers and welcome to another edition of the conversation right here on News Central TV. Now, today on the program, we will be looking at the political situation in Kenya, where the Supreme Court has rejected President Kenyatta's bid to change the constitution. And up north, Tunisia's president again dissolved parliament after lawmakers defied and met against his measures.
Interesting times in
It seems
Africa,
like the problems
especially.
in Tunisia never seems to come to an end from one problem to the other.
It's a continuous discussion we've been having all through the year. Now, today on the conversation, the Supreme Court in Kenya has dealt a blow to proponents of the Building Bridges Initiative, otherwise known as BBI, after a 7-judge bench ruled that the quest to change Kenya's constitution was not procedural. Attorney General Kihara Kairuki, the IEBC and BBI co-principals Uhuru Kenyatta and Raila Odinga had filed an appeal at the Apex Court after the Court of Appeal threw out the BBI push.
Chief Justice Martha Koome said the 2010 constitution has been resilient to survive 21 unsuccessful attempts at changing it. She said 19 of these attempts were through the parliamentary initiative, while 2 were through the popular initiative route. One of the 2 popular initiative attempts the court found was made by President Uhuru Kenyatta, who they ruled does not have the right to initiate constitutional changes using the popular initiative route. And now join us live on the conversation. We have Gautham Bhatia. He is an author and constitutional lawyer from Berlin, Germany. Also, we have Mkangi, a legal consultant, public governance and human rights. He's also a member of the defunct committee of experts that drafted Kenya's 2010 constitution. Gentlemen, welcome to the conversation.
Thank you.
Thank you.
So I'll start with you, Mkangi. What do you make of the Supreme Court judgment on the BBI, and why has this BBI issue been so contentious? Because it's not the first time we're having this issue now. So what do you make of this ruling?
Well, first, on the second strand of your question, why has it been contentious? And it's seeded in the political dynamics of this country, and particularly in the offing of the handshake between the opposition leader, or we would say the then opposition leader and former Prime Minister Raila Odinga, and the President Uhuru Kenyatta, when from the contentious presidential elections of 2017, they came together, made a pact, and initiated the Building Bridges initiative. From the time they made the handshake and came up with this initiative and the institutions thereof, which, like has been and explained in our previous discussions, did drive a wedge between the president and his then partner, the Deputy President William Ruto. Yeah. So from the offing, BBI had trouble, particularly coming from the disruption that it did make in the political dimensions of this country. But the other part of it, which is technical, was also how it was seeded, how the institutions, right from the task force, in as much as the courts have, declared that the task force was correctly initiated, the process crafted and engineered, but eventually, when you look at it, it's really because it sought to disrupt the political pact, the political journey and agreement between President Uhuru Kenyatta and Deputy President William Ruto, And as we say, or as they say, three is, is a crowd. When Honorable Raila Odinga came into the mix of things as it is right now, it did drive a wedge between William Ruto and Uhuru Kenyatta.
Yeah.
And that's where the trouble really started.
Okay.
So the technical issues thereof eventually were seeded in the political dynamics that were engineered by the handshake and its eventual process, that is the Building Bridges initiative.
Okay, thanks, Bobby. I'd like to bring in Gautham here. Reading the judgment of the BBI, the Supreme Court judges faulted most of the proposals of this Building Bridges initiative. My question to you, Gautham, is did the sponsors and proponents not think carefully about this before embarking on such an expensive and time-consuming exercise? You would think the Attorney General of the Republic of Kenya and legal advisors of the President and former Prime Minister would have looked deep into this.
So I think that one thing that you see across different countries is that the political executive always tries to push the limits of a constitution, and specifically when there are silences in the constitutional text. And in this case, the particular silence in question is in Article 257 of the Kenyan Constitution of 2010 that sets out the route to amend the constitution via the popular initiative. And Article 257 is textually silent on who can be a promoter, and it doesn't actually specifically bar the president from initiating a popular initiative. And so I think that when you have that kind of a textual silence, the executive always looks at it and says, oh, okay, look, here's a silence, there's a silence, here's where we can try and just push and see how far we can go and try to upset the constitutional scheme. And that's where the role of constitutional courts is so important, to lay down that line and tell the executive that you can't exploit these silences to aggrandize or concentrate power in yourself, and take over, in this case, a provision that was clearly meant for the people and for civil society to use to amend the constitution.
Okay, I'll still stay with you, Gautham, because you're talking about the constitution and some of the lapses. We know that the Building Bridges initiative consisted of a series of 78 proposed amendments to the Constitution of Kenya and spanned 13 of its 18 chapters. Now, in your opinion, in what ways is the current 2010 Constitution lacking, and what areas actually need reform?
No, I don't think that. So there are two different questions here, right? One is that it's a question of constitutional policy or legal policy, whether or not a constitution needs reform. So in this case, for example, reforms included adding various posts of deputy prime ministers, various new offices, adding a judiciary ombudsman, things like that. And all of those issues are issues of constitutional policy. And if either the parliament through the parliamentary initiative route or the people through the popular initiative route decide that it's worth debating or discussing those proposals, then that's the route that should be taken. What the Supreme Court has found is that if you do want to reform the constitution in these ways, you have to follow a certain specific procedure. And one thing that you cannot do is you cannot appropriate the route that's meant for the people to take. The president cannot appropriate that route. So I think that's the real core of the finding, and the rest is, I think, a question of policy debate.
Thank you, Gautham. Back to you, Bobby. One of the judges, one of the Supreme Court judges, in his pronouncement, did say that the 2010 Constitution of Kenya was sort of self-cleansing. It has a way of reforming. It was reforming itself. As someone that was instrumental and that was part of the committee that birthed this constitution, in what ways, what do you make of all of this? Is the constitution lacking? And why was President Uhuru Kenyatta and Raila Odinga hell-bent on, adding this additional post and all the things that came with BBI?
Well, first of all, as Gautham said, there's no perfect constitution, and a constitution is a living instrument. And so, as the life of any nation goes on, and the constitution being the benchmark of how the life of that nation and the state thereof progresses. So with time, changes must come into place or into play to accommodate those changes. So in terms of its perfection, that is something that is of a myth of any constitution. And so the constitution, and through the provided avenues, needs to fenestrate and adapt to the currencies of that nation. And so in terms of what is lacking or not will depend on the analysis and the proposals and the agreements thereof that come from the institutions of that nation and state. And so it's hard to say, and it's very subjective in most of the times of determining what is lacking or not. And that's why when you look at BBI and the proposals that Uhuru Kenyatta and Raila Odinga brought forward, most Kenyans, in my analysis, and even right after the pronouncement of the Supreme Court and even previously, there was commentary coming from Vox Populi that their proposals around increasing, or as they termed in their report, the BBI report, expanding the government, national executive by having more posts was not a priority. It did not meet the interests of Kenyans. Kenyans who are facing many socioeconomic challenges right now. And so it was very much in disagreement with the current popular discourse. And that's why when civil society players, after a myriad and very many times through commentary, through other avenues of voicing discontent, and also trying to advise the state, and particularly the two major interlocutors of this process, failed to heed the advice, eventually went to court to seek the court's decision and advice as to the issues that were being proposed by the two gentlemen, being read by most Kenyans as being politically selfish, that this was pretty much a political agreement, a political MOU, which unfortunately the president and the former prime minister sought to entrench by disrupting the current constitutional order. And I think that's why these proposals were met with a lot of disappointment from a good chunk of Kenyans, because they did not meet the challenges of the day, and they were quite literally read into as being a political pact between the two gentlemen.
Bobby, if I may come in here, you talk about this being a political agreement, and it's between Uhuru Kenyatta and Raila Odinga. Now, with this verdict from the Supreme Court, how much of a blow is this BBI verdict, especially for Uhuru Kenyatta, who a lot of people said this particular Building Bridges initiative was actually to put him back in the political atmosphere. So how much of a blow is it to Uhuru Kenyatta and Raila Odinga?
It is a big blow, and especially with the pronouncement coming, 3 to 4 months to the elections. Raila Odinga being one of the front runners, Uhuru Kenyatta having fronted him as his favorite candidate, and again this pretty much
Bobby.
operating was there that BBI was, yes?
Okay, go on.
BBI was not an altruistic venture into repairing or rehabilitating and refining the Constitution, but was a political pact being wedged into the Constitution. So it's a big blow, even in terms of just the spirit and energies that go into the electioneering period, and even in the simplicity of the losses and the blows that any competitor in a competition would take towards the end goal. So in that stance, and especially now for the opposing side, the other front runner, the Deputy President, William Ruto, who has all along opposed BBI, this decision seems to vindicate him, that BBI was all along a pact and a venture to sideline him and to ensure that he did not gain ranks into ascending to the highest political office of the country. So in those imaginations, I would think that William Ruto's team and he himself are really riding high on this, and they're going to capitalize on this pronouncement of the Supreme Court. Raila Odinga's team, Uhuru Kenyatta, and the venture that was in ensuring that Uhuru Kenyatta, in one way or another, remains within the strongholds of and the reins of statecraft. This has been dampened in a major way. But as I was saying, particularly with the context of the fact that we are in the critical stage of electioneering, and especially towards the presidential elections, definitely this is a big blow to Uhuru Kenyatta and Raila Odinga.
Thank you, Bobby. I'd like to bring in Gautham here. Does this verdict by the Kenyan Supreme Court make Kenya the poster child and a beacon for separation of powers? Does it affirm the Kenya's judicial independence, or is not yet Uhuru? Because Raila Odinga is on record as saying the BBI is on halftime, and he will push it in future and reintroduce the push to change the constitution. What do you make of all of this?
I think a lot will depend upon the actual judgment, which is not yet out. That's going to be out on Tuesday, and it's going to be 1,500 pages long. So we'll have to read that carefully to see exactly what it entails. But I will say two things. I think so. One thing that both the High Court and the Court of Appeal had held was that there is a basic structure of the Kenyan Constitution, and if you want to amend, alter the basic structure, which the BBI amendment was attempting to do, then you couldn't use the procedure set out in the Constitution, but you would have to recreate the conditions under which the Constitution was framed, this four-step sequential process, on the logic that if you want to effectively completely overhaul a Constitution, you're not amending it, you're effectively recreating it. So you have to go back to how it was created in the first place. Now that finding has been set aside by the Supreme Court. And so there is no longer, the basic structure doctrine is no longer applicable in Kenya. So a future, say, BBI Part 2 would not have to run the gauntlet of that test. So that's one thing. So in that sense, the judgments of the High Court and the Court of Appeal have been watered down a bit by the Supreme Court. And the other thing, and I think this is where it will be really important to read the judgments carefully, is that one of the reasons the Supreme Court gave for rejecting the basic structure doctrine was that the tiered amendment process in the Kenyan Constitution, whereby for certain entrenched provisions, you have to go via the onerous 10-step route of the popular initiative, which requires extensive public participation and so on. The Supreme Court said that is an adequate safeguard against constitutional dismemberment. And therefore, you don't need to use the basic structure doctrine as a protector of the Constitution. So a lot now will depend upon how the Supreme Court has really interpreted the provisions of Article 257, because there were two crucial issues. One was, can the president initiate an amendment via this process. The Supreme Court has said no, because that is meant for the people, not for state organs. And secondly, was there adequate public participation in the process? And here the Supreme Court has said that barring the one schedule, there was public participation. So it will be really important to see what the Supreme Court has said over there. And I think that therefore we can only really talk about how strongly this judgment protects the Kenyan constitution and the separation of powers once you have read it. But these are some of the pointers to look out for in the judgment.
Now, Gautham, as a constitutional lawyer going forward, and from the discussion we've also had with Bobby, how important, and does the Kenyan Constitution of 2010 have enough protection from politicians who try to amend the Constitution for their own personal benefit and at their whims? Is there enough protective layer, rather? I
think this is something that history really is going to have a verdict on. And right now, the protection is really contained in Article 257. That's the really important provision, because that now, by virtue of this judgment, prohibits state organs from effectively initiating amendments. But of course, as we know, there are ways to indirectly circumvent these provisions, where you can always put up proxies, you can be behind the scenes. So formally, and this is what was attempted in this case, the court saw through it, but you can imagine more subtle attempts where it seems on the surface that some independent citizen actually is initiating this process, but really behind the scenes it's state organs.
They're pulling the strings.
And so that's where you need to have courts again being really vigilant. So I think the safeguards right now for the Kenyan Constitution, Article 257, of course, social movements that brought these cases to court, like in this one, and the courts then actually really implementing Article 257 strongly and shutting out state organs from trying to hijack a process that's meant for the people.
All right, Bobby, Gautham has clearly pointed out that most of the constitutional process for this BBI has been largely faulted by the Supreme Court. We also have people talking about it being a political agreement. Now, we know that the political rival, that is Raila Odinga, said this is just half time. And we know that he's also vying for presidency in 2022. That's in August now. Now, supposing he comes in and wins as the president, do you think that this BBI initiative will actually come back into the front burner? And if you look at this BBI initiative, it's actually the winner takes all structure. What exactly is so wrong about having a more inclusive political system by the so-called BBI?
Oh, well, in the first place, in terms of whether BBI will come back, that's we'll wait and see first, depending on the outcome of the elections. But again, we have to state that since the Court of Appeals decision, in fact, the political trajectory, rhetoric, and game plan from Raila Odinga actually changed. And it's because previously the energies, and as I mentioned before, BBI was meant to come into play and affect the elections, the political formations and coalitions and agreements towards the August 9th, 2022 elections. And so in that regard, it was pretty much fashioned for this political climate. And so the question that is still out there is after it was practically defeated, because the ends were meant for this electioneering period. And that's what...
Oh dear, I think we have some connection. Yes.
Despite energies changed, because the Azimio team, the Raila Odinga team, realized that even with the appeal and the decision that came yesterday, 4 months into the elections, even if the Supreme Court would have allowed the appeals optimally pronounced that this was not going to be used or come into play for the August 9th elections. And with the superfluidity of Kenyan political interests as it is with many other jurisdictions, interests change, formations change. BBI had this context. The question, and my feeling is that probably this will be thrown into the garbage bin because its use has already been, or its shelf life has already expired.
Yeah.
And yes, in the future we may have other
Initiatives similar to this.
attempts to initiatives to rehabilitate or to change the constitution, but those may be different, fashioned away from BBI and depending on the political interests and formations and factions that will come into play. So this one was meant to pretty much accommodate Raila Odinga and Uhuru Kenyatta, and I think since
okay. Thank you, Bobby. I would like to come to Gautham just before we wrap
the Court of Appeals made its sat and looked into it.
Okay, thank you, Bobby. I'd like to bring in Gautham here. I read a book once by Kenya's anti-corruption, the head of Kenya's anti-corruption agency, John Gitongo. The title of the book is Our Turn to Eat. And it talk about the grand theft that happened under President Kibaki, and a lot of people will say that corruption hasn't changed much. The BBI initiatives sought to expand government and more executive positions and create more seats in parliament without the IEBC to make it more inclusive, because the proponents argued that it prevents the winner-takes-all system of Kenyan politics. And we know, judging from Kenya's election history in the past, how volatile that has been. Was the BBI the only way to make politics more inclusive and make sure that everybody has a chance at the top, or is it just an avenue to keep politicians happy and make everybody eat from the national cake, if I may put it that way?
No, I think there are two things here. One is as far as the increase of the constituencies goes, right? So the issue, I think, is not so much of increasing inclusiveness, which I think everyone agrees is a good thing. But it is that who should be the body that's tasked with that, given that, as both the Court of Appeal and the Supreme Court observed, constituencies are a really important source of political patronage. Which is why, in Kenya and the Kenyan constitution, as well as in different countries, this is a task that you have to delegate to a body that is functionally and financially independent. Of the political executive, because otherwise it becomes, the same entity becomes both the player and the umpire. And one thing the BBI was trying to do was to effectively direct the IEBC about how it should conduct its business, and in that fashion, at least indirectly, bring it under a state control. And so I think the issue was not so much the goal of increasing inclusivity or maybe increasing or diversifying the pie, but that the process through which this was being done raised suspicions that the actual goal was something else. So I think the real takeaway is that if you do want to increase inclusiveness in the polity, then the Kenyan constitution actually sets out a very participatory and inclusive process through which these questions can be debated, which culminates in a referendum for a constitutional amendment. And as long as that process is followed, then it's fine. But because these changes are so far-reaching, it's really important that the process be followed strictly.
Thank you very much, Gautham. I would like to say a very big thank you to you, gentlemen, for being a part of today's conversation. Bobby Mkangi, legal consultant, public governance and human rights, and Gautham Bhatia, author and constitutional lawyer. It's a pleasure having you join us and share your insights with us.
Thank you.
Thank you. Thank you.
And this is where we go for a quick break and come back with more stories, especially in Tunisia. Stay tuned. Thanks for staying with us. You're still watching the conversation right here on News Central TV. Now, on the first phase, we dealt with situations in Kenya where the Supreme Court has actually rejected President Uhuru Kenyatta's decision to reform the constitution. And of course, this took a toll on the Building Bridges initiative, which, according to the president, was to make an all-inclusive government. Now, if you thought the problems in Tunisia was over, well, you're far from it. Tunisia's President Kais Saied on Wednesday announced that he is dissolving the country's parliament 8 months after suspending it in a July power grab. This comes hours after parliamentarians held a plenary session online and voted through a bill against his exceptional measures.
Now, President Saied has done his best to stop. He had done his best to stop that from taking place, blocking online video platforms like Zoom and Microsoft Teams throughout Tunisia for part of the day in a bid to prevent the MPs from voting on the motion. Meanwhile, people on the streets of the Tunisian capital, Tunis, have continued to express distrust in the elected representatives a day after the president dissolved parliament in a blow to the country's democracy. Now, joining us live from Tunis, Tunisia, to discuss this, we have Emmanuel Ben Amar. She is head Department Law and Policies at the African Center for Artificial Intelligence and Digital Technology. Thank you very much for joining us, Manel.
Thank you so much for inviting me, and thank you so much for choosing this topic.
Now, Manel, President Kais Saied denounced the parliament's move as a coup attempt and said those responsible had betrayed the nation. Was the online session held by the lawmakers illegal? And how significant was this vote calling on condemning the extraordinary measures President Kais Saied took last year?
Oh, yes. First, so the decision of the president of the Republic of Tunisia was made because of this illegality made by parliamentarians since the parliament is not functional. So it is closed since 25 of July, and the decision was taken and it was published in the official journal of the Republic of Tunisia. So the parliament has no right to vote or to gather in parliament, so they did this to destroy the nation and the people.
Yeah, but the people of Tunisia, I mean, the Tunisia is meant to be a democracy. The president took extraordinary measures. It's been since July last year. Don't you think it's time to, allow dissenting voices? How long does the president, and now the president has dissolved the parliament, does he have the constitutional right to dissolve parliament?
Yes, the president of the Tunisian Republic was elected by more than half. It is said that the majority of the Tunisian people, as you know, this vote was made thanks to his program, which is aimed at the fight against the corruption. Today, we are faced with the fight against corruption, and the closure of the parliament reflects the first step towards the fight against this corruption. So the parliamentarians, as you know, they want to come back to defend their personal interests, and it's not the general interest. It's not the interest of the Tunisian people, and that's why I can say that the decision taken by the president of our Republic, Tunisia, was democratic.
You talk about that it was actually constitutional for him to go against the parliament, but he talked about it being as a result of the corruption going on in the parliament. Now, if you look at constitutional amendments, if you look at a state of democracy in Tunisia, do you feel the president would actually write dissolving the parliament and right now suspending the prime minister in the first place? Do you think that all these actions were actually democratically right by the president?
Yes, of course. The decisions taken by the president of Tunisia has to the decisions of the people, of the Tunisian people, as we say. And talking about what we are waiting for a good future for Tunisia, and we are waiting for a new constitution. And this is what we are waiting for.
Now, Manel, a lot of people were actually happy with that because you said that this is what the people wanted, a dissolution of the parliament due to corrupt practices going on in there. But now we have the economic in Tunisia not actually going better under the President Kais side. Do you feel he's still doing right in helping the country?
Yes, the present economic situation is mainly caused by these parliamentarians, and it is perfectly normal to see our economy that has been bad for a decade. But today, with this change, we are proud of these decisions. We are proud of the decisions taken by our president. And we are ready to rebuild our country without corruption and without outside interference. Our country needs young people. And it is in this context that the President of the Republic has given us the green light to improve our country's economy through work, optimism also, and to fight against corruption.
Now, Manel, as a lawyer yourself, principles of democracy does entail the separation of powers as espoused by A.V. Dicey. The president has usurped parliament he says these extraordinary measures are taken to protect Tunisians. When will Tunisia get back to full democratic mode? And what's the guarantee that after December, Parliament will be allowed to reopen? What is the end game for President Kais side here? Because he has usurped all the powers of the executive and abrogated powers of the legislature to himself. So he's both judge and jury in this case.
Well,
and that's not
honestly,
exactly democratic.
Yes, it is purely democratic. Yes, it is purely democratic, and it's purely in law. Actually, what has happened in Tunisia, we can say it's purely democratic. So the president of the Tunisian Republic has taken decisions.
Even taking the Judicial Council's power, is that democratic? So
Yes.
It's not just the legislature, it's also gone after the judiciary.
Yes, this decision has taken during the demonstrations of the million of Tunisian people. As you know, it's the Tunisian people who has taken this decision before the president. So it's pretty democratic.
Okay, Manel, are Tunisians ready for the July 25 constitutional referendum, which Kais Saied has talked about?
Yes, of course. This is what we are waiting for. And this is what we are ready to rebuild. We are ready to rebuild our country, because our country needs us and needs young people, needs leadership, youth leader without corruption.
Now, Manel, there was there was a period of consulting. I'm not sure if that's still ongoing online to suggest the content of the referendum that will happen in July. And a lot of critics said, they looked at Tunisia's internet penetration, and they also said, people in rural areas who are not tech savvy that it's not all inclusive. How is that going, and what are some of the questions that are in this online consultation form that have been handed to Tunisians?
Yes, I want you to know that all the decisions taken are related to the Tunisian law. So it's illegal and it's democratic. And as you know, as I said also, that the decisions are made by Tunisian people, first of all, and the will of people. So what we are waiting for is to rebuild our country.
Now, my question is on the consultations going on, online consultations that Tunisians are meant to fill in forms online to ask, to answer questions on what they want in the constitutional referendum. How is that exercise going, and is it inclusive? Is it all inclusive? All Tunisians able to participate in it?
Yes, of course. All the nations are able to participate with democratic and with honest.
Okay, Manel, let's talk about the elections now. Saeed said the country will have elections in December this year, but he mentioned that those against him will not participate in the election. Now, in my opinion of democracy, or rather in the worldview opinion of democracy, it's a free rule for everyone to participate in. If you want to vie for a post, you can. Now, with the president saying that those who are conspiring against him will not partake in the election, do you see that as still constitutional and democratic?
Yes, of course. We are living in a democratic. I want you to know that we are living in a democratic side. We are able to participate in any elections. The president has taken the decision to build or to concrete elections as soon as possible. So we are able to participate and we are able to give our vote.
Thank you very much, Manel. I would like to say a very big thank you to you for being a part of this conversation. I will clearly monitor situations in Tunisia as you progress towards your July referendum. Thanks for being a part of the conversation.
Thank you so much.
Thank you. This is where we'll draw the curtains for today's edition of the conversation. The first belt, we dealt with the Kenya Supreme Court now nullifying the President Uhuru Kenyatta's plea for a constitutional referendum, especially with the Building Bridges initiative, of which there was supposed to be elections in August. But right now, with this bill being put down, we see a lot of stormbacks for President Uhuru Kenyatta and, of course, the person he's supporting, Raila Odinga. Meanwhile, for the people who came here, they said this would give a good opportunity for the deputy president who is running against Raila Odinga, that is William Ruto. And on the second belt, we dealt with Tunisia with the dissolving of the parliament. Well, we'll see how far that goes. And that's where we'll draw the curtains for today's edition of The Conversation. Do join us again next week for another edition of The Conversation. I am Rita Omodia.
And I'm Gbenga Aborowa. See you next time on The Conversation. Bye-bye.